Morning, Your Honors. Thank you for allowing me to speak. It's a privilege to be here. If we altered the facts of Mr. McCarroll's case just slightly, I think it might bring the issues into a little bit more clarity. Suppose Andrew McCarroll took the Accutane in Florida and started to feel ill there, and then moved to Alabama, and then had his medical treatment in the town next door in Mississippi. Well, in Florida, we have a 4-year statute of limitations. In Mississippi, we have a 3-year statute of limitations. Alabama, we do not get the benefit of the discovery rule. And he decides that he's going to bring his case in New Jersey. Under that set of facts, what statute of limitations should presumptively apply? I mean, it's conceivable. It happens all the time. And I submit that Section 142 strikes the proper balance and gives the proper guidance to courts when dealing with these issues. So in my example, if you apply Section 142, the plaintiff does not get the benefit of the Mississippi 3-year statute or the Florida 4-year statute, but does get the benefit of the New Jersey statute unless a presumption can be overcome by the defendants. So to answer the question posed early, what policy reason is there to apply Section 142 versus 146? And I would submit that the issues that you're trying to address with statute of limitations are different, and that's why the courts say take these on issue by issue analysis. 142 actually protects New Jersey companies in the majority of cases. It's interesting. I think I could probably argue their appeal under a different set of facts, right? Because 142 says that if you're coming from Mississippi or Wisconsin or Minnesota with a 6-year statute and you come to New Jersey to file a case, you only get the benefit of a 2-year statute. It actually protects our company, our corporations, and it gives guidance so that the corporations know that if they're going to be sued here, this is what the rules are. And the plaintiffs know, if they come, what the rules are going to be. And it also carries out the legislature's intent, which is stale claims. We consider claims stale after 2 years. And it does other things. It helps us with the administration in our courts, consistent with what the legislature envisioned. You can take Atlantic County. There are thousands of Accutane cases. Under the current regimen, Judge Johnson is required to do an analysis, theoretically, of 50 different state laws on statute of limitations. From an administration point of view, that's a nightmare, where if the presumption was where it should be under 142, that determination in a multi-county context would be made early, up front, and everyone would be guided. And if you apply 142, we're actually taking advantage of the experience of our trial courts. Our trial courts know how to deal with statute of limitations issues. They know how to deal with Lopez hearings. What happens if you just run with 145 in the special interest, in the most significant interest? What is going to happen? So a Mississippi plaintiff doesn't get a Lopez hearing. That's a jury determination. But a New Jersey plaintiff, you do have a Lopez hearing. So it really makes sense for everyone.
Counsel, does the compelling nature of your argument draw strength from the fact that we're dealing with a products liability case with a pharmaceutical corporate defendant located in New Jersey? And would it lose some of its compelling nature if we were talking about an individual defendant involved in a more common negligence action where the injury and interaction between the two people, the plaintiff and the defendant, did take place out of state?
Well, I think then it's just as simple, because if there's a thin reed to be here, then presumably the out-of-state statute of limitations would apply. But the defense
Isn't the starting read the same point, though? I mean, the defendant is physically a resident of New Jersey, and
right,
you have
and
every right to sue that
yes,
individual here in our courts.
But it's very interesting when you look at it. So, for example, you could look at Coronet, Hefner, and the Pitcock case, where 142 was applied in Pitcock, but I submit to you, if you would have applied 142 to the Coronet state of facts or the Hefner state of facts, you would have applied the foreign jurisdiction statute of limitations, because New Jersey had no substantial or no real interest in applying its statute of limitations. And it's interesting in Coronet, because while I might not have agreed with how we got there, because I think analytically I didn't agree with it as a plaintiff's lawyer, the result would have been correct. Because if you would have used a 142 analysis and you looked at a Florida company who manufactured the product and marketed the product, no doubt most courts, I believe, would have arrived at a foreign statute of limitations applying, not New Jersey, because Johnson & Johnson was only sued here because they were the parent here.
So you think, from a policy perspective, it makes sense to use the 142 analysis in all tort actions as opposed to our Camp JC approach for substantive issues, where we follow the location of the injury presumptively?
And I think it does for all the reasons I've stated. And I can envision many circumstances where that's not necessarily favorable to the plaintiff, but it's consistent, it's predictable, everyone knows what the rules are. We don't have courts handling multi-county litigations, trying to do analysis of 50 different states on a statute, whether they should be there or not. And the issue of forum shopping, because the issue was raised, I would say that's a red herring here. When more than half of the states have statute of limitations that are more liberal than ours, is that really a concern? And should it be a concern? Because this court in Gantes made clear when that issue came up that, as long as there's a legitimate basis to be here, that's not forum shopping. This is not a slender tie. The McCarroll case is not the slender tie that should concern a court and did concern the court in its analysis in Gantes. And it's also interesting that the defense, and I never got a chance to address this, said that the Product Liability Act somehow should impact, and it shows some kind of preference for protecting, pharmaceutical companies. But that was also rejected outright in Gantes. The court in Gantes, absolutely said that the Product Liability Act was never meant to address that. The legislature could have if it wanted to, and the Product Liability Act just doesn't apply to pharmaceutical cases. It applies to all kinds of products, and Gantes was very clear, and it said that because the legislature did not do something special for products cases, there's no reason to treat them different than regular cases. So at the end of the day, when you look at what is the most fair way to do this, what's the most predictable way, not always in the plaintiff's favor. As I said, I think I could rise under a different set of facts and argue 142 protects the defense in a significant number of cases.
Well, let's take that one.
Right.
You mentioned like Wisconsin.
Right.
If Wisconsin has the longest statute of limitations,
Right.
and the person takes the product there, they're going to file probably in Wisconsin if they're out of time in New Jersey. I mean, let's face it, there's a certain amount of strategic calculation going on.
I think that's true, but there are reasons why plaintiffs file cases in New Jersey other than the statute of limitations. They file it because they think the substantive law, for some reason, might be in their favor. They might think that the treatment of experts is more fair than it is in other places. They might think our courts are just better able to handle these cases and our judges are more competent, something I believe, than they are in other places, and that they are going to get a fair shake in New Jersey.
How about the expectations of the defendant? Can we say that their expectations of not getting a fair deal is less persuasive when they're sued in their own state, where they've manufactured the product and marketed the product? It's more difficult to argue that their reasonable expectations have been violated, no?
No, I agree with that entirely. And that's why I said I'm almost surprised at the positions that are taken here, because predictability is what any defendant wants. And they get that here. If somebody's going to come here and sue them in their backyard, they know what the law will be. So I guess, unless there are other questions.
I have one last question.
Sure.
If we were to adopt Section 142, do you think the court would have to modify or overrule its analysis in Camp JC or Cornett in any way?
Not at all. I believe that Camp JC is a logical extension of Gantes, that's where the law related to liability or tortious conduct lies, and you can have two different starting points. It's the only thing that we're really talking about. I thought it was wise. Would I like the court to modify Coronet just a little bit? Because I think Coronet, to be honest, the court found that there was no conflict, and then applied the foreign jurisdiction's statute of limitations, which is really contrary to Roe and all the other cases that came before from this court. But if the court had Coronet and applied 142, they would have come to the right result for the right reason. I think Coronet, the court came maybe to the right result, but for the wrong reason.
So in Camp JC, we applied Section 145, 146, the restatement.
Yes.
And the restatement obviously has 142.
Yes.
So the drafters of all these restatements think that this is part of a piece. We were only dealing with one piece, I guess, in Camp JC, not the total piece.
That's exactly right. And I think Camp JC was right on the money, as was Gantes. And this issue really has never come up before here. And, there were some very, very smart people who read a lot of cases and a lot of law review articles who had no bias, who came to the conclusion that statute of limitations should be governed by 142 and other and other conflicts for tortious conduct by 146.
Well, there are some people who thought that based on Fu and Ernie versus Marola, that Camp JC was a big step. It took the suggestions in the restatement that had been used to inform New Jersey's conflicts analysis and solidified them into cement in our new test.
Right.
And that was perceived as a bit of a change, as our appellate division has noted in this instance. So this would be actually taking another big step if the court were to adopt the suggestion of 142 and make it our presumptive choice of law analysis for statutes of limitations. Don't you agree?
Yeah, I think it would be a step. It would be an affirmative decision made by the court that, given all the policy reasons that focus on the statute of limitations versus tortious conduct, this is how we're going to handle statute of limitations, and everybody knows what the rules are. So I agree, and I guess I disagree a little bit. I think Camp JC's was really a logical extension of Gantes. I thought it was the right decision. I thought it was an enlightened decision, frankly. I thought it gave people guidance. It doesn't always operate in the plaintiff's favor, But that's not why we're here. We're here to try to come up with the right result. We can focus just on Mr. McCarroll and come to a result, but is that right for all New Jersey citizens and non-New Jersey citizens going forward? And when I say New Jersey citizens, I also mean New Jersey corporations.
Thank you.
So at the end of the day, I really believe that Section 142 strikes a fair balance between protecting New Jersey companies against stale claims, preserves the rights for the wrongfully injured who don't sleep on their rights, and provides predictability and fairness in the administration of justice here in this great state. And I really do appreciate the privilege of being here as amicus. I know you didn't have to permit me to be here, but thank you very much, unless you have any other questions.
Thank you.
Thank you.
Smith.
Thank you.
Thank you.